Very warm good evening to all. Today we'll be discussing a topic which is very serious in nature, and in fact, it is in today's time, quad has become a very big issue all over the country. And if you remember, a few years back, the Delhi was known as a rape capital. Now you know what I'm talking about. Rape capital of the country, because there were so many rape cases, and Nirbhaya was like the biggest thing happened, and thereafter there was a lot of discussion, agitation in our country, and there were changes in the law relating to the rape laws, and especially for the women. There were also other cases that like acid attacks. There were also this what we call eve teasing. Other all these things came into the pictures, and the any offenses against women were like it was dealt with a lot of stringent laws. Now what happened, there are cases came up before the court where the rape charges were false, and in those cases the man was humiliated, or maybe false prosecution, he was insulted and he was behind the bars, and thereafter these matters got settled. Now out of few these matters, which under even under 376 rape matters, there were matters which were of emerged out of the love affairs. The girl and the boy were in a relationship for love. It was a love affair for a long period. The boy refused to marry later on, and the girl went and filed as rape charges because they had a physical relation, on the pretext that they will get the lady believed, the lady or the woman or the girl in the relationship believed that the person will marry me. Sometime it happened with the married man also. And the smallest touchstone we can touch in the domestic violence where it was live-in relationship. But we have seen in D. Velu Swami's case, there are some conditions which has to be fulfilled for live-in relationship. They both has to be unmarried. They have to pose before the society as a married couple. All these things matters. Now, as a person, as a lawyer also, even I will believe, when I was researching what to speak for today, I was researching and I came across this judgment which says that the charges, when there is a rape charges, these matters can also be settled with the permission of the court. But of course, the matter went before the High Court, and the subordinate court, the trial court, will not do it. Now there are some judgments, and the Karnataka High Court had an opportunity to go through all the judgments of the Supreme Court also. And this is one judgment where I found that they were in relationship. Later on, the girl said that I do not want to continue, and the court agreed to the compromise arrived between the parties. It is very surprising and shocking. But when you read this judgment, I will share the citation of the judgment. Just a minute. It is Sathish K versus State of Karnataka in criminal petition number 4172 of 2022, decided on 23rd May 2022. And if we see the heading, you will have an idea what I am talking about. Rape. Karnataka High Court address whether offense under section 376 IPC can be compounded. Compounded का meaning मैंने परसों बताया था कि क्षमा मांगना in case of settlement or arrived between the parties. We can call it समझौता. Actually, जो दोष है उसके लिए क्षमा मांगना. Now this is very surprising कि rape cases में भी it can happen, but this is one judgment which speaks this, and it has the opportunity to discuss all the previous judgment of the other high courts also. Delhi High Court also one judgment, Supreme Court judgment also. Now it basically touches one more judgment, that is Gyan Singh Kaur judgment. Now in Gyan Singh judgment, if you see, what we find is that any dispute, if it is a family element and it is not affecting the society, then with the permission of the court, it can be compounded. Now I'll read a small para from this judgment. So you'll have an idea. During the pendency of this petition, both the parties, the petitioner and respondent number 2, have filed joint compromise application under section 320, read with 482 of CRPC. Respondent number 2 and the petition submitted that they have compounded offences, and respondent number 2 submits no objection for quashing the criminal proceedings against the petitioner. Both petitioner and respondent number 2, along with their counsels, have appeared through video conference, and the parties were identified by the respective counsel. It was in Corona pandemic period. Therefore, this video conference. The allegation against the petitioner that he had sexual intercourse with the respondent number 2 under the pretext of marrying her. Therefore, the complaint came to be filed. Subsequently, both decided to resile from each other and compounded the offense. Therefore, both of them filed joint application for closing the matter. In view of the submission of both the parties having compounded the offense, and in view of the judgment of the Honorable Supreme Court, this is very important in the case of Gyan Singh versus State of Punjab and another, wherein it is let down that where the parties have settled the dispute between them and the same is not affected to the public, the court can quash the proceeding. In view of this same, parties have settled the dispute amicably, and therefore IN number so and so required to be allowed. Accordingly, IN number so and so is allowed, and subsequently criminal proceeding against the petitioner in case number so and so pending on the file of First Additional Chief Judicial Magistrate, Bangalore Rural District, arising out of criminal so and so, registered by Kadugodi Police Station for the offences under section, read the section properly, 417, that is cheating, and 376 of IPC, which is rape charges, is hereby quashed. Now, this was very surprising even for me to read, but then if you read the judgment properly, you will understand that the court says when the parties have settled the amicable dispute, even if the charges are rape and there is a no heinous crime committed. Now, heinous, see, rape can be pulling the girl, taking away, kidnapping her, something like that. Here there was some relation between the parties, and court, see, in some of the matters, even you will find the person who has raped the girl, he marries her later on. Now, from any stretch of imagination, also any stage of thought, also you will find this is not morally wrong. You will feel, but the court says that if they have made a family out of it and they have children out of it, it's not right to disturb the family. That is the court view taken by the court. It may be your personal opinion. You may agree or may not agree. One. Number two, also the court says that even if they do not quash the charges, what will happen? The matter will proceed before the court, and thereafter, what will happen? The complainant who says, I do not want to continue the charges, she may not support the prosecution case, and ultimately it will result into acquittal of the charges, rape charges. It will be a precious, it will be wastage of precious judicial time of the court and wastage of the public money also in running that trial. That is why sometimes court interrupts and say their matters amicable settled between the parties, and if it is not affecting the society as a whole, and if charges are not very grave, and even if it is 376 and it was a love affair or it was between the families, then court says that they will quash the charges. So this is one judgment, because we have always grown up with this. When you become a lawyer, or those who are going to become a lawyer here, they will feel rape charges, murder charges. In this matter, it is not next to impossible. Murder charges also they do not do it. But in rape charges, the cases which are discussed in this matter, Sathish case, you will find out that they have been quashed. So it will be a good reading material for all of you. I'll share this judgment later on in the group. Thank you so much. I move to Arnav. Arnav, kindly unmute yourself.
Yeah, good evening, ma'am.
Good evening. Just a minute.
Yeah.
Arnav is going to read a very, I would say, one of the case where we rarely come across such kind of matter.
Yes, sir. Can I start?
Yes, you can start.
This criminal original petition has been filed seeking a direction to direct the petitioner to undergo sentences in concurrent matter related to the punishment imposed as against the petitioner in CCNOS 126 of 2017 dated 24 January 2017. On the file of the learned district Munsif, cum judicial magistrate, Thiruvandanai, Ramarathapuram district. The learned counsel for the petitioner would submit that the petitioner was convinced in all the CCNOs 1 to 6 of 2017 and sentenced to undergo 1 year rigorous imprisonment for the offence under section 454 of IPC and sentenced to undergo 8 months rigorous imprisonment for an offence under section 380 of IPC and directed to run the sentences concurrently by separate judges while the trial court delivered the judgments in all 6 cases on the same day. Failed to specifically mention as to whether the petitioner has to undergo and concurrently or not. He further submitted that the petitioner is a third gender and he is in the advanced stage of HIV. The prison hospital did not have infrastructure to treat HIV positive patients, and that upon the petitioner is a transgender, now he has been incarceration of imprisonment from the date of judgment, namely 24 January 2017. He also relied upon various judgments of the Honorable Supreme Court and the court to run sentences concurrently as contemplated under section 427 of the CRPC. The learned government advocate submitted that the petitioner have committed very serious offences under sections 454 and 380 of IPC. If the petitioner allowed to undergo imprisonment concurrently again, the petitioner will commit the same nature of offence. So, he vehemently opposed this petition and praised for dismissal of this plea. Heard the learned counsel for petitioner and the learned government advocate CRL SID appearing for the respondents. The petitioner was convinced and sentenced to undergo rigorous imprisonment for a period of 1 year, rigorous imprisonment for the offence under section 454 of IPC, and for a period of 8 months rigorous imprisonment for an offence under section 380 of IPC. In CCNOS 1 to 6 2017 by separate judgment dated 24/7/2017. Throughout the judgment passed by the same court, the trial court did not mention specifically as to whether the petitioner has to undergo the sentences for all 6 cases and concurrently or not. In this regard, it is also relevant to rely upon judgment of the division bench of this court reported in 2018 to LWCRL 773 in the case of Silva Kumar versus the Inspector of Police, Sindhugiller Police Station or Ors, held as follows. The scope of section 427(2) of CRPC is that in respect to the convict undergoing imprisonment, the sentence of imprisonment passed on subsequent convictions should run concurrently. The reason for being that the sentence for life must be understood to mean as a sentence to serve remainder of his life in the prison unless commuted or remitted by the appropriate authority and the person having only one lifespan. The sentence on the subsequent conviction of imprisonment for a term of imprisonment for life can only be superimposed the earlier life sentence and certainly not added to it. A division bench of this court had an occasion to consider a case of similar nature in K. Arson and others versus the state of Tamil Nadu, reported in Manu TN 1954 2012 6 CTC 510. The relevant portion of the judgment is extracted hereunder. The crux of the question involved in this matter is whether the court can invoke the inherent powers of section 482 of the Code of Criminal Procedure, herein referred to as CRPC, for granting the relief under section 427 CRPC for ordering the sentence imposed in the former case to run concurrently along the sentence from imprisonment awarded in the latter case. It is seen that the two conflicting views expressed by two learned single judges in respect to invoking the jurisdiction under section 482 CRPC for granting the relief of order the subsequent sentence to run concurrently with the previous sentence awarded against a person in an earlier case which necessitated the learned referring single judge to refer the matter of a division bench to resolve the said conflict between two decisions. It is seen that a learned single judge in A. Palaniswamy Kithan versus Inspector of Police, B1 Police Station, Kadavithi, Coimbatore, 2011-3, MWNCR 55, 2011-4 of 2019, MLJCR 813. After referring to various judgments of Honorable Apex Court, has held in paragraph 27 as here under 27. In the instant case on hand also, the provision section 427 CRPC was not invoked either in original cases or in the appeals. Under the above circumstances, section 427 CRPC cannot be applied in separate and independent proceedings by this court in exercising the inherent jurisdiction under section 482 CRPC. Another learned judge, A. Paulraj versus Maria Chilamatel, 2011 for MLJ CRL 798, has taken a contrary view by placing reliance on the decision of the larger bench of the Honorable Apex Court and held as hereunder. Since the larger bench of Supreme Court in State of Punjab versus Madan Lal Supra, he had considered on application filed under section 482 of the CRPC the decision rendered in MS Kundwa versus State of Andhra Pradesh Supra may not be applicable, and invoking jurisdiction under section 482 CRPC is indeed available to the petitioner. We have gone through the two above conflicting decisions rendered by the two learned single judges 13.0. It is the pertinent to refer the following decisions rendered by the other high courts in respect to the issue involved in this matter. 13-1 division bench of the Andhra Pradesh High Court V. Venkatasvarlu versus State of Andhra Pradesh 1987 CRLNJ 1621 has held hereunder. The High Court, while exercising its revisional jurisdiction suo motu or in exercise of its inherent power under section 482, can direct the sentences to run concurrently as provided under section 427 CRPC, even though the convictions and sentences that have been passed in the additional sessions judges of different sessions divisions have become final. 13-2, a full bench of Madhya Pradesh High Court in Sher Singh versus State of Madhya Pradesh 1989 CRL LJ 632-1 as hereunder. Inherent powers of the High Court can be invoked under section 482, even if the trial court or the appellate or revisional court has not exercised its discretion under section 427(1) of the code in directing running of previous and subsequent sentences concurrently. The inherent powers of the High Court is not in any way fettered by the provisions of section 427(1), and it can be invoked at any stage even if there is no such other passed under section 427(1) of the trial court or appellate revisional court, and even though the conviction has become final. 13-3, the view taken by a divisional bench of the Andhra Pradesh High Court and the full bench of Madhya Pradesh High Court are in line with the view taken by the larger bench of the Honorable Apex Court in State of Punjab versus Madan Lal 2009-5 SCC 238. As a matter of fact, as already pointed out the learned single judge of the court in A. Paulraj versus Maria Chellamai 2011-4 MLJ CRL 798 also referred the division of Honorable Apex Court in M.R. Kundwa versus State of Andhra Pradesh 2007-2 C 772. The two-bench judge and preferred to place reliance on the decision rendered by larger bench consisting of 3 judges and Honorable Apex Court. At this juncture, it is relevant to refer following decisions for the Honorable Apex Court. In the Union of India versus K.S. Subramanian, AIR 1976 SC 2433, the Honorable Apex Court has held as follows. The proper course of High Court is to try to find out and follow opinions expressed by larger benches of the Supreme Court in preference to those expressed by smaller benches of this court. That is practice followed by the Supreme Court itself. The practice has not crystallized into rule of law declared by the Supreme Court. If, however, the High Court is at the opinion that the views expressed by the larger benches of the Supreme Court are not applicable to the facts of the case, it should say so, giving reasons supporting its point of view. According to the Honorable Apex Court in State of Uttar Pradesh versus Ramchandra AIR 1976 SC 2547 has held as follows. Constitutional position as regards the power of the court to go behind the orders of termination to find out motive of the government is clear. Even in the cases where the High Court finds any conflict between the views expressed by larger and smaller benches of this court, it cannot disregard or skirt the views expressed by larger benches. The proper course of High Court in such a case is to try and find out and follow the opinion expressed by the larger benches of the Supreme Court, in preference to those expressed by smaller benches of the court, which practice hardened as it has into the law, is followed by the Supreme Court itself. The above decisions rendered by the Honorable Apex Court made it crystal clear that the High Court has to follow the opinion expressed by the larger benches of the Honorable Apex Court in preference to those expressed by the smaller courts. 50. As far as the issue invoked in the matter, we are consider the view of learned single judge A. Paulraj versus Maria Chelmai, 2011, for MLJ CRL 798, has rightly placed reliance on the decision of the larger bench consisting of 3 judges of Honorable Apex Court in State of Punjab versus Madhav Lal, 2009, 5 SCC 238, which is binding on this court and is taken correctly. It is to be stated that invoking the jurisdiction under 482 CRPC in order to grant the relief under section 427 CRPC would not be amount to altering, varying or modifying the findings of the trial court or appellate court. On the other hand, it is always open to the court to exercise power under section 482 CRPC to secure the ends of justice. It is needless to say that the court has to exercise its judicial discretion for invoking the power under section 482 CRPC for granting the relief under section 427 CRPC, 427 CRPC for on the basis of the facts and circumstances and gravity of the charge leveled against the accused in each case. The result, we are answering the reference to effect the inherent power of the High Court under section 482 CRPC can very well be extended to the issue discretion ordering the sentence imposed in latter case on conviction to run concurrently with the sentence imposed in the former case as provided under section 427 CRPC. On hand, in this case, on hand it is seemed that the petitioner was invoked in 2 cases did not commit any other offences similar to those cases. Further, it is also seen that the learned judicial magistrate Satya Vangalam sentenced him to undergo imprisonment for a period of 2 years for both sentences with offences under sections 454 and 380 of IPC to run concurrently. The High Court of Bombay, Nagpur bench held as follows. Precedents. We are fortified in the view of our judgment in the case Abid Khan @ Salman Mukhtar Khan Pathan versus State of Maharashtra reported in Manu MH 0954 2013, 2014 All Measure CRI 1719 in which Justice Sukri authored the judgment. 3 cases were tried and convicted by 1 court metropolitan magistrate, whereas in the case before us, 2 different magistrate courts, 2 different places tried and convicted these petitioners. This is the only distinguishing factor. Otherwise, the observation made therein are perfectly applicable to the cases before us. We are also fortified in taking the view on the basis of judgment delivered by Honorable Supreme Court.
Just a minute. Can you see this screen?
Honorable Supreme Court in the case of Sorry, no, I didn't hear you.
Then continue.
Yes, sir. So we are also fortified in taking the view on the basis of judgment delivered by Honorable Supreme Court in case Western versus State of Kerala reported in Manu SC 1177 2016, 2016-10 SCC 307. Honorable Supreme Court converted the sentence into concurrent cases. There were 11 cases. Approach of the trial court. It is true that the Bandra court and the Tumsar may or may not be aware of cases pending in 2 different courts, but it is certain that both these courts are fully aware of the cases dealt with by them. Can we say that 2 courts were unaware about the legal provisions contained in section 427 of the CRPC? These two courts have not been given the benefit of concurrent theory of sentences. These two courts are fully aware about the provisions of probation under Offenders Act, and they have to deny the benefit to the petitioners. Ultimately, the judicial officers dealing with the case will also have a human element on it. So, while convicting the petitioners, they must be having a repetitive tendency of these petitioners while committing these offences in their mind. They are fully justified in denying the benefits of concurrent theory. The theory of deterrence must have obeyed with their mind, but what we feel is that the trial courts are unaware about these provisions of law. We say so because there is no discussion on this issue. Judge may consciously deny benefit, but it must be reflected from the judgment. In the case Abid Khan, there was a discretion to place the matter before Registrar General. In order to centralize the judges in the state of Maharashtra, we feel some more needs to be done. Hence, we intend to direct Registrar Judicial to circulate the judgment amongst all the judges of the state of Maharashtra. We hope the judges of the trial court and the appellate court will consider the provisions of section 427 of CRPC while dealing with the issues of sentence. Ultimately, it is the discretion of the concerned judge whether to grant him before or not. It depends upon the facts of each case, but it should not have happened that due to the ignorance of provisions of law, a rightful convict may be denied the benefits of this provisions of law.
Thank you. Thank
In
you.
view,
Arnav,
thank you.
What Arnav read is about the section 427 of CRPC. Let's see what is section 427 of CRPC. Sentence of on a offender already sentenced for another offense. Due to paucity of time, I won't read the complete section here, but I will tell you in a nutshell what is. What Arnav read is about section 427 CRPC. The facts of the case that a person was convicted for 6 CRs, there's 6 FIR in the court, and he was convicted for 8 months, 1 year, whatever. Now he was convicted differently for each FIR, but there is section 427 CRPC which say that this imprisonment should run concurrently. Concurrently मतलब एक साथ उसकी सजा चलेगी, ऐसे नहीं कि एक में 1 साल मिली, एक में 2 साल मिली है. If there are 2 cases, तो 1 और 2 मिलकर उसको 3 साल की सजा लेनी होगी. He will has to only undergo 1 and 2 is all the offenses, all the punishments for the offenses should run concurrently. एक साथ उसकी सजा चलेगी, क्योंकि there may be many sections to one. Normally it happens in debt cases. चोरी की केस में ऐसा होता है कि there are उसकी 5 मोबाइल की चोरी की है, तो उसको 5 मोबाइल की चोरी के लिए एक ही साथ सजा, 6 के 6 से एक ही साथ चलेंगे, तो उसको एक ही साथ वो सजा दी जाती है. ऐसा नहीं कि उसको एक FIR खत्म होगा, उसकी सजा खत्म होगी, फिर दूसरा imprisonment चलेगा. It is not like that. This is called concurrent theory. And the court say कि they should also be the accused who is convicted. He should also have while granting him, it may be a probation offenders act. He also read the probation offenders act. Probation offenders का मतलब उसको सुधारने का एक मौका दिया जाना चाहिए. And they may be habitual offenders. There may be reasons. Somebody who is stealing every time, there may be some reason. Maybe his poverty, maybe something happened in his family. So court sees all this background while convicting an accused. Who are in the family? Who are his dependents? Now coming back to judgment, this judgment say it was from saying even if you read the last para again here, what Arnav read, that in state of Maharashtra, a lot needs to be done. That the judges, they are right. The judicial judges who are convicting the accused, they are right, because it is a deterrent theory. उनको रोकने के लिए भी उनको सजा देना जरूरी है. But at the same time, we should consider from human element whether a person who is convicted of 6 FIRs for 1, 2, 3, 4, 5. Can he be punished differently for each FIR, or these all the punishment should run concurrently? There the section 427 comes into play. So this was a judgment, very different judgment, and even the judgment says that at the lower stage, that is in the trial court, the judges may not be aware about the same. But when it comes to High Court says that it has to be run concurrently. So this is also one judgment which can be useful to all of us as a lawyer, and it should be in our everyday studies also. So whenever you read a judgment, you get so many ideas. Here also, Provision Offender Act was also mentioned. If you're there is one case, for one case, maybe वो छेड़खानी का हो या छोटी मोटी लड़ाई हो, if your person is convicted, maybe an accident case, you can always go for Probation Offenders Act. उसके अंडर आप कोर्ट से रिलीफ मांग सकते हैं कि this is first offense of that person. But of course, not in heinous crimes and crimes which are more than 7 years punishment is given. So this was all about. Today we will discuss one practical aspect of the our practice. See, when we say we are first generation lawyer, here many may be first generation lawyer. The most difficult part of our profession is to get the work. Money follows your work, but first part is कि cases मुझे कैसे मिलेंगे. Now हमारा जो profession है वो आपको advertisement करने के लिए allow नहीं कर सकता है. Now there is a bar council allowed website, also one page, and there is also restriction कि you can put whatever you can put your name, you can put your telephone number, but not everything. And to advertise is against the ethics of the legal profession. Now then, how do you get the work? So it is the most difficult part. But there is a practical approach to this. Being a lawyer, the first thing you should do that you should expose yourself to the court premises. One, you should always go to the court premises, and there you may encounter so many people. First, of course, the judicial officers, the judges. Number two, the lawyers. Now, how do judicial officers can help? If as a junior you're sitting in the same court for some time, even the judge recognizes that you are observing the court proceeding, they may give you legal aid cases and they may help you out also. Legal aid cases ये होता है जो lawyers को afford नहीं कर सकते हैं, those who are poor and needy. In those cases, legal aid cases, the lawyers are appointed by the court sometime. And you can also apply for legal aid also. There are legal aid committees in some courts also. Now, second is the lawyers who are around. If you go regularly, there may be senior lawyers who are burdened with a lot of work. They may have to apply for certificate copy, or they are stick into one court and they have to got one court work of another court. That time they may send you. So you have to be around there. Thirdly, you have relatives, you have friends group. Now we are in the WhatsApp. I'm not saying you circulate, I have become a lawyer, but at least your family, your friends, your alumni from college or the school, they should know that you have become a lawyer. Because after the graduation and 3 years course or the 5 years course after 12, it takes about 17 years or 18 years to become a lawyer. In those in this journey of this your study as a student, you get to meet so many people. Some may become an engineer, some may become a doctor, some may have gone for civil services, some may have become to government jobs. Now these friends, if they don't know you, how they will approach you as a lawyer? The first thing is to inform at least your near relatives that I have become a lawyer. Because I see that, no, I don't know the law. How should I tell? See, even your relatives, your neighbors, your friends know that you are the first generation lawyer, one. Number two, you are new lawyer. But you can always take cases and take the help of your senior lawyers, senior friends, and they are going to help you. So it's always better to expose yourself as a lawyer. If you just sit at home, you don't go to court library. One lady lawyer once asked me that I don't get work. I asked her, in last 2 years, how many times you went to the library, court library? She said, not even once. So if you don't go to court library, if you don't go to the court library is one thing which enriches you with a lot of knowledge. And there you get to hear so many stories, maybe inspiring stories of other lawyers also. So there are